Hey YouTube family and GN subs, we have a very important marriage case that is coming up in the Supreme Court, and I want to give you all the information about it. I also have a little surprise for you in terms of good news, right? Work authorization extensions. We'll talk about that. I'll give you a peek of currently what's happening, but the main focus is Department of State versus Munoz. We're going to jump into it, dive into it, and give you all the information that you need that may help your immigration case when your spouse has been denied at State Department and you have the petition that's pending and your spouse can't get to the U.S. This may be the case that's going to save the day. So hey, I'm going to jump right into it. Those of you who are new to the channel, you can only get me at hrg@graylaw.com. Generally, what I do is I bring you good news. That's what I do. And today is no different. So if you filed your I-765 request for extension of a work permit on or after October of 2023, your receipt that comes in the mail only gives you an automatic extension of 6 months, 180 days, right? So USCIS just announced, because there's a backlog, folks, automatic extensions are going to go for 540 days now. That's fantastic. I remember during COVID when there were delays in issuance of work authorization, they did extend it as well to 540 days. So if you have a receipt that says 180 days that was filed on or after October of 2023, that is an automatic extension of 540 days. I'm going to give you the law. There's a link in the description box below. You can show your employer, my automatic extension is 540 days, not 180 days, so I'm still authorized to work in the U.S. Really important for a lot of people who were losing their jobs because of this. So this is great news, folks. I always bring it to you. Good news stuff. Let's jump into a very important Supreme Court case, Department of State v. Munoz. So what is this case? Let me tell you what happened. So U.S. citizen spouse marries a foreign individual. They are processing outside of the U.S. as opposed to adjustment of status in the U.S. The rules are a little different when you're outside of the U.S. at State Department, okay? So the spouse, male, goes in for the interview, and the consular officer notices a tattoo on his arm. The consular officer believed that the tattoo was a gang symbol and that the individual had been involved in gangs overseas. There is a provision of law that if the consular officer has reason to believe that the individual will be engaged in unlawful activity when they enter the United States, they can deem the individual inadmissible and not allow them to come to the U.S. Not only that, they don't even have to tell you the reason why. They could just say, we have reason to believe unlawful activity. We're not going to tell you what activity it is, but your spouse is not going to be able to come to the United States. So this case has been on appeal at the Ninth Circuit. Now it's going to the Supreme Court. And the Supreme Court has two major questions, right? What are the liberty interests of the U.S. citizen spouse? That question hasn't been raised before. And does the citizen spouse have a right to their foreign spouse to come to the U.S., number one? And if there is a liberty interest, then under the section of law that we'll discuss, whether or not a consular officer, they don't need to tell you the reason they believe your spouse is going to be engaged in unlawful activity. So those are two major questions, and it's all about due process, folks, right? All right, so let's jump into the section of law, right? 1182A3 is the section of law. And there's two provisions that I want to talk about here, right? So this case, the Munoz case, talks about the consular officer having reason to believe that the foreigner will be engaged in unlawful activity, right? So that's one. Number two is that the consular officer has reason to believe that the individual has been or will be engaged in terrorist activity. All right, I'm going to give you the facts of another case that I have that's similar to Munoz, and that may help my client outside of the U.S. So I have a client from Afghanistan. His parents were born in Iran, and his petition was denied at the U.S. consulate because the consul had reason to believe that he or his family had been involved in terrorist activity. Now, there's many provisions under the terrorist inadmissibility statute. I tried, and I will continue to try to find out exactly specifically what it is that they're alleging that renders him inadmissible. This Munoz case may help me solve that problem. I'm going to be very curious to see what the Supreme Court says about my U.S. citizen spouse's constitutional due process right to know exactly what the allegations are. So what does this mean for spouse petitions in the U.S., if anything, right? Currently, there are cases in the U.S. that say the petitioner, the U.S. citizen spouse, has a liberty interest in the application and the petition being processed in a timely, reasonable manner. We've used those cases before. I think in this case, this will solidify that it is the U.S. citizen spouse due process rights and liberty interests that is at stake. And certainly both State Department and USCIS, that's DHS, they have to afford the U.S. citizen spouse due process in either case. I am so looking forward to seeing what happens in this case, and I'm going to keep you updated on what happens. Oral argument is coming up in the Supreme Court this month. And after oral argument, when the decision is made, I'm going to come back and give you an update on exactly what's happening. Okay, YouTube family and GN subs, thanks so much for watching GrayLaw TV. I'm getting close to 100,000 subscribers. Good news, subscribers. Click the button, like and subscribe. Help me out here and go to my content. See my videos. A lot of good stuff, a lot of content over the last 5 years. All right, we'll see you next time.